Hello, and welcome to the first video of the online arbitration training course. In this video, we'll aim to give you an overview of what arbitration is. In this, we'll cover the following broad topics. First, what is arbitration? How is it different from other ADR processes? What are the advantages and what are the disadvantages of arbitration? On the first, what is arbitration? Simply put, arbitration is a formal dispute resolution where you get a binding and enforceable decision outside of the courts. The decision is usually given by a person that the parties have themselves chosen, or at least appointed by a process that the parties have chosen. The decision is also legally enforceable in that you can use the assistance of the courts to get the decision enforced. The common misconception people have is that arbitration is some sort of out-of-court settlement. Now, settlement in the true sense of the term means a process where parties are able to resolve a dispute by mutual agreement. Now, that's fundamentally different from what arbitration is. A settlement can happen if both parties themselves agree by way of a negotiation. If a third party neutral is there, present, and guiding the parties to that resolution by way of a settlement, that is mediation. But arbitration is very different. Arbitration is where a third party neutral actually decides a dispute. So it is not a midway ground that the arbitrator is trying to achieve. It is actually a decision on who is wrong and who is not. Now, in that limited sense, arbitration is quite similar to court processes, because in courts, much like in an arbitration, you get a final and binding decision where the court holds one party right or wrong, and that is the end of the matter. There are some inherent advantages to arbitration as a result of this flexibility that is there and the method of dispute resolution. First, arbitration offers a procedural flexibility by virtue of being a process that is outside of the court systems. We will deal with these elements in a little bit more detail in the later videos, but bear in mind that existing processes in courts, including things like having to physically attend a court hearing, having to comply with very detailed processes, do not need to be followed in arbitration. Second, in an arbitration, a party or parties have the ability to choose their own decision maker. Now, that choice can either be exercised themselves or it can be given to someone that the parties trust. It need not be either a judge or anyone with a legal qualification. Arbitrations are typically faster and more cost effective. We will come to both of these elements in a little bit more detail, because whether arbitration is faster or whether arbitration is cost effective will depend very much on how the arbitration is conducted, but it certainly has the potential to be both. Next, once you get a decision in arbitration, it's extremely difficult to challenge it. You would have heard that in courts you get a decision and it goes on an endless round of appeal. On the contrary, in an arbitration, once you get a final and binding decision, it's usually conclusive, except very minor grounds on which you can challenge it. Again, an element we'll come to in later parts of this training module. Finally, and importantly, in an arbitration, you can get a decision even if one of the parties is not cooperating. This is a fundamental distinction from negotiation and mediation, where it is imperative that both parties have to agree to the ultimate outcome. Those are the advantages. But arbitration is not without its own disadvantages. For instance, the element we talked about, the win-loss decision. While on the one hand, parties might see that as being good, on the other hand, what it does is it stifles creative decision making, which negotiation and mediation can allow. What people say, thinking out of the box or exploring solutions which are not limited to the dispute. An arbitration cannot achieve that. Second, an advantage we said is that an arbitrator's decision is final. But that on the other side of the coin is a disadvantage, because if the arbitrator gets it wrong, then you have very, very limited grounds of challenge and there's simply no appeal against that decision. This again is a key difference from court decisions and what some might perceive is a disadvantage of arbitration. And finally, a key disadvantage in arbitration is, as it is currently practiced, it is still very expensive and it is still very time consuming. But this is not something that is inherent to arbitration as a mode of dispute resolution. We will cover these elements in a little bit more detail in the following modules in this online training course. I hope this video has given you a good overview of what the basics of arbitration are. You can test your knowledge on these matters with a few questions that follow this video. Thank you.